Okay, we're going to go ahead and start, and I'm going to, at this time, ask a man who needs no introduction to give an introduction, and that is Judge Keith Watkins from right here in the Middle District. So please join me in welcoming Judge Watkins.
Thank you, Alan. I was asked to make a few remarks in my introduction, and I'm going to make a very few. And if there's any time left over, our keynote speaker will be able to speak. I am the keynote speaker, not the keynote speaker. It's a great honor to be asked to make a few remarks today and to introduce our keynote speaker, retired Chief Justice Brent E Dickson of the Indiana Supreme Court. Justice Dickson, welcome to Alabama. It's not the end of the world, but you can see it from here when it's not raining. Now, I'm a trial judge in federal court, and I have great respect for appellate judges like Justice Dickson, and I think we have some Alabama Supreme Courters in here, a couple of tall ones. Oh, they were here.
We're here.
Okay, I'm taking notes. You see, appellate judges grade the papers of trial judges. And so I have great respect for appellate judges, except for our appellate judges on the 11th Circuit. They've affirmed me so many times I've lost all respect for them. Justice Dickson is a real judge. One of our judges was speaking to some fifth graders in October, and you can't make this up. A fifth grader came up to him and said, "Hey, mister," he said, "are you a judge?" He said, "Yes." He said, "Are you a real judge?" "Yeah, I'm a real judge." He said, "What time's your show?" Well, happy birthday, Alabama. The big day is December the 14th, and I must say, as a lifelong Alabamian, this has been a well-planned and executed celebration led by Governor Ivey and the Bicentennial Commission, Senator Orr, Lisa Tell, Jay Lamar, the Alabama Department of Archives and History led by Steve Murray. Is Stephen here? He's outside, I think. I remember Milo Howard, if that dates any of you, and helped along today by Faulkner Law and the Blackstone and Burke Center for Law and Liberty. And the focus, I must say, of this whole celebration has been spot on. This year has been an awakening, these 3 years have been an awakening to civic education and civic engagement, and that's rightly the focus. If you look at the website of the Bicentennial Commission, that's what it's all about, lesson plans and civics and civic engagement. President Reagan said, if we forget what we've done, we won't know who we are. These words were received as prophetic at the time, but were in fact anticipatory. There's a video on the internet called Polytech, and it's at Texas Tech. It's students interviewing students. They interview about 13 students, most of whom couldn't tell you who was in the Civil War or who won it. Couldn't tell you who the vice president was. Couldn't tell you who we got our independence from. Or what year. One said 1640, and others said, no, it's 1941. All 13 of them could tell you who Snooki is. And I see some blank looks from gentlemen older than me. Snooki's apparently on Jersey Shore, but I don't know that. I don't know I don't even know what Jersey Shore is about. And all 13 of them could tell you not only who Brad Pitt was married to at the time, but who he had been married to before. Justice Dickson, in a recent poll, it was revealed that 13% of Americans think that Judge Judy is on the United States Supreme Court. And 10% of those are college graduates. Newsweek says that we've become a culture of incurious know-nothings. 2/3 of Americans cannot name the 3 branches of government. 1/3 can't name one branch of government. 25 of our top universities that have history degrees, including all but one Ivy League, do not require a course in American history for history majors. A few years ago, I was handling the naturalization ceremony at Auburn, and the Dean of Architecture Bazad Nakavan, who's married to Bob James's niece, was naturalized. He'd been here for 25 years at the time. We invited a bunch of junior high and high school kids to come, and Auburn, of course, was happy to feed them and all that. And then afterwards, we had the folks who had been naturalized to come, and the kids could ask them questions. An 8th grader asked Dr. Nakavan this question: "You've been here for 25 years, you're married to an American woman, you have an American child. Why did you wait so long?" And he's from Iran. And so he stood up very soberly and he said, "You don't understand. When I took that oath to abjure any allegiance to any king, prince, or potentate," I don't know what a potentate is, but it came to me, Jennifer, during my speech you heard last week, that I think a potentate is a cross between a potato and a rutabaga, but I'm not sure. He said, when I took that oath to abjure any allegiance to any king, prince, or potentate, I turned my back on 5,000 years of Persian history. And you don't do that lightly. It occurred to me at that moment that we are common law married to this country if we were born here. We're accidental citizens. We didn't have a ceremony. We didn't sign any papers. We didn't take a test. We didn't study anything. We didn't have a federal judge to say grace over us. We didn't do any of that. And we act like it. And we, as Reagan predicted, have turned our back on just a mere 230-something years of history. Because we don't know. How are you going to talk to somebody about the Constitution if they can't even name the 3 branches of government? It's just totally lost on them. That's why the focus of the bicentennial celebration should be on civic education and then civic engagement. Alabama is just the right size and demographic for a controlled experiment in civics. Wouldn't it be grand to use this celebration to kick off a 10-year experiment in Alabama to double or triple the level of civic awareness in our state? It's measurable and it's doable, and the structure is in place with this bicentennial structure that we have could be converted just to that, and we can measure it, and I say that we can do it. The civics teachers want to do it. The civics teachers showed up at that thing in Auburn, had lots of great ideas, but they're not getting support from the establishment. Now, our keynote speaker, Justice Dickson. Justice Dickson, let me introduce you to your audience before I introduce you to the audience. So 43% of Alabamians are Baptist. 43%. Some stripe or another, and I understand there's 386 stripes. So if you are not a Baptist, raise your hand, but you'd like to be? Justice Brent Dickson was the 100th Justice of the Indiana Supreme Court. He's the second longest serving in Indiana history and the longest serving in the last 166 years. Notice I didn't say he served for 166 years. He's the longest serving in the last 166 years. In fact, he served for 38 years and was elevated to Chief Justice in 2012. He was born in Gary, Indiana, educated in public schools in Hobart, Indiana, and received his BS from Purdue University in 1964 and a law degree from Indiana University's Robert H. McKinney School of Law in 1968. On his bio on the website, I'm sorry, I had to look, he worked as an insurance adjuster while he was going to law school. And he also practiced law for a number of years as what I refer to as a county seat lawyer. He's also served as a pianist for the Salty Dogs Dixieland Band at Purdue. Justice Dickson and his wife, Jan Aikman Dickson, who is herself a distinguished public servant, have 3 adult sons and 9 grandchildren. Justice Dickson has taught law, written about law, and speaks frequently on the law with an emphasis on state constitutions. Let's give a warm Alabama welcome to retired Chief Justice Brent E. Dickson.
Well, I join Judge Wilkins' enthusiasm about the role of education, civics education, and where we are and where we need to go. And I would make the same recommendations for our state as well. What a spectacular building this is, and how delighted I am to be here in the presence of the Chief Justice and his colleagues and all of you. Thank you very much. Dean Campbell, very much appreciate being here. The symposium organizers and the sponsors invited me here to share some thoughts about state constitutional law generally, but mostly about our experience in Indiana with rejuvenating the role and the importance of our state constitution during the past 30 years that I've been on the court. When I was appointed to the Indiana Supreme Court in 1986, I really lacked any particular knowledge about state constitutional law. It may be that the people in the survey didn't know the difference between the three branches of federal government, but how many people don't know that we have state constitutions and federal constitutions? I may have known that, but I didn't know much more about it than that. In my 17 years of private law practice as a courthouse square lawyer in Lafayette, Indiana, I'd never been involved in a case in which an issue of Indiana constitutional law was raised. But my ensuing 30 years on the state Supreme Court changed all that. I became fascinated with our state constitution and how crucially important and instrumental state constitutions are to the integrity of judicial decisions. Let's begin with some history. As most of you know, when the federal Constitution was adopted in 1787 and the Federal Bill of Rights in 1791, the framers were crafting a framework for both empowering and limiting the federal government. Our federal Constitution envisioned a unique system of dual sovereignty, where every American was a citizen both of the state where they resided and of the federal government. The federal framers sought to create a government with designated powers to protect and serve the people, but also with that power limited to preserve individual liberties. But the limitations of the federal Constitution and the Bill of Rights was not enacted to limit state or local governments. That was the exclusive business of state constitutions. In Barron versus Baltimore, a unanimous opinion in 1833 by Chief Justice John Marshall, the United States Supreme Court specifically held that the Federal Bill of Rights offers no protection against any state action. Reading from that opinion, he wrote, "The entire Bill of Rights was intended solely as a limitation on the exercise of power by the government of the United States and is not applicable to legislation of the states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the power of its particular government as its judgment dictated." It was left to the state, that's the end of the quotation, it was left to the state constitutions to prescribe any limits on state and local governments. And the citizens of the several states, through the framers of their constitutions, undertook their task seriously and used language that they felt most appropriate for the particular needs of their states. This language often differed extensively from the federal model. In Indiana's 1851 Constitution, that was our second Constitution, our first one was 1816. We beat you by 3 years to get that first one out, but we're very, very similar in so many ways. But in our first Constitution was adopted by, as yours was, by a constitutional convention, delegates, and that Constitution was then submitted to Congress for approval. And our first Constitution did the same thing, but in 1851, the Constitution was actually submitted to the voters in Indiana, and it was ratified by voters. So it was both crafted at convention and then approved by voters. That Constitution did not, for example, use the language of the federal First Amendment to protect religious liberty, but instead it used seven different clauses, each with its own unique language to protect Indiana's residents. So it is with Alabama's 1901 Constitution's Article 1, the Declaration of Rights, Section 3, which it also addresses religious liberty and does not parrot the federal First Amendment. We know, of course, that following the Civil War, the 14th Amendment to the U.S. Constitution, adopted in 1868 with its Equal Protection of Laws clause, but it really was not, until I turn the page here, it was not until the middle of the 20th century that the United States Supreme Court began to use the 14th Amendment to begin to selectively incorporate various, but not all, provisions in the Federal Bill of Rights as guaranteeing individual liberties from intrusion by state and local laws. So think about this. When our constitutions were written, Indiana's in 1851 and in 1816, and when those of the Alabamas, all 6 of your constitutions were being drafted, including the current 1901 version, our framers had to be assuming that it was up to them to protect individual citizens. The concept of the Federal Bill of Rights having any applicability to the states was gone. It hadn't come to life yet. And entirely the framers were they were creating the government under which we live in our states and giving it powers and limiting its powers. So our framers had to be assuming it was all up to them. Now, in the middle 1900s, when the U.S. Supreme Court began to use the Equal Protection Clause more robustly and to apply several provisions of the Federal Bill of Rights to state and local laws, civil liberty advocates responded by bringing more and more claims in the federal courts rather than the state courts. And since the federal Constitution's Supremacy Clause obligated states to follow the federal Supreme Court decisions, many lawyers seem to lose interest in asserting individual liberty claims under their respective state constitutions. There seemed to be a resulting nationwide loss of interest in state constitutional law. But the proactive jurisprudence of the Warren Court diminished under the Burger Court and certainly under the Rehnquist Court. And as the United States Supreme Court in the late 1990s became less proactive in the area of civil liberty protections, legal commentators across the country began to urge resort to state constitutions. And the resurgence of state constitutional law began. State Supreme Courts were then faced with the challenge of interpreting their state constitutions in the context of a body of federal constitutional law that had developed and was now applicable to the states. A variety of methodologies also began to be employed by various states when interpreting their own state constitutions on issues that were covered by the Federal Bill of Rights. At one extreme, some states followed a lockstep approach, which basically they resorted to federal interpretations and did not provide any separate analysis of their own state constitutions, nor the intention of their framers. Thus, if the issue is one of free speech or unreasonable search and seizure or double jeopardy, for example, these states simply imported federal jurisprudence and interpreted their own state constitutions in accordance with federal precedent. And if federal precedent changed, or federal jurisprudence changed, so did such lockstep states. Other interpretive models, sometimes referred to as the primacy method or the dual sovereignty method, looked to and applied state constitutions first, or at least independently, as the determinative source of their authority. These approaches seem far more consistent with history because the citizens of the respective states created and empowered their state governments on condition that they function as formulated and as limited in power. State constitutions were crafted to describe the functioning and to articulate those limitations. It's hard to understand why some state Supreme Courts ignore their own state constitutions in favor of the federal one. At least it's hard for me to understand it. To the extent that a state has written its own constitution choosing language differing from the Federal Bill of Rights, fealty to state constitutions may require divergence from federal jurisprudence. Even language that's identical to the federal Constitution may yield a different interpretation when based upon the disparate contexts in which the language was selected when the state constitution was drafted. The validity and the importance of individual state-based analysis was expressly recognized by the United States Supreme Court in 1983. There, the Michigan Supreme Court had reversed a drug possession conviction of a defendant who claimed unlawful search and seizure. On appeal by the state, the U.S. Supreme Court reversed and held that the Michigan court misapplied federal precedent. Importantly, the Supreme Court held that if it is not clear from the face of the state court's opinion that the case was decided on a state law ground that is independent and adequate, or is adequate and independent from federal law, then the case is reviewable by the U.S. Supreme Court, which will assume, quote, the state court decided the case the way it did because it believed that federal law required it to do so, unquote. That case, Michigan v. Long, made it clear that state Supreme Courts are the ultimate interpreters of their state constitutions. We heard this morning from Dr. Brown about the voting rights and the two particular federal decisions that seem to go against that rule, the Gomel v. Lightfoot and Reynolds v. Sims case. But as to the application of the Bill of Rights to individual freedoms, I think that Michigan v. Long is still sound law and is an important lesson to our federal courts, or to our appellate courts. That lesson for our state appellate courts is this: if they wish to be insulated from federal review in a case where their decision is based on provisions in their state constitution and not on analogous provisions in the federal one, they simply need to write the opinion to clearly express that reliance on state, not federal jurisprudence. Or the state courts can, and often do, write about both claims, the federal and the state claims. But as long as they clearly talk about, separate the two and articulate an independent analysis based upon their state constitution, that's going to be not touched by the federal court. It's going to be left standing. This is why computers are better, isn't it? You just scroll instead of having to separate pages with old hands. Of course, this approach by our appellate courts requires that lawyers assert the claims. And if the lawyers don't assert the state constitutional claims, the appellate courts and the trial courts are not free to necessarily go off and invent a claim that is not presented. But if the lawyers actually assert it and argue it, then the appellate courts are free to make that decision based upon state constitutional law. Advocacy for the important role of state constitutional law has recently come from a surprising source, a federal judge. And I'm talking about Federal Circuit Court Judge Jeffrey Sutton, Sixth Circuit. He published an article in 2009 that was entitled, "Why Teach and Why Study State Constitutional Law?" In this engaging piece, Judge Sutton writes this conclusion. He says, "My point in all this is not that innovative state decisions are good or bad. That's beside the point. What's important is that no lawyer worth his or her salt can be a good advocate in today's world without appreciating the possibility and the value of raising state and federal claims in representing a client. Ask many law students why they went to law school, and you will find a common answer among many of them: the opportunity to make a difference in groundbreaking issues of the day. A lawyer cannot do that today without understanding state constitutional law and appreciate its significance in modern individual right disputes." Now, in actual practice, we often see lawyers asserting both federal and state constitutional claims and doing it with increasing frequency. If the United States Constitution applies to grant relief, of course, states must abide in accordance with that federal supremacy clause. But often federal jurisprudence does not compel relief, in which case the states are perfectly free to interpret their own constitutions to provide greater individual liberty protections and grant relief accordingly. In Indiana, our renewed interest in applying our Indiana Constitution began in the early 1990s. 3 of our 5 justices, in fact, became quite engaged. Our Chief Justice wrote a law journal article entitled Second Wind for the Indiana Bill of Rights. 2 other justices began teaching courses on Indiana constitutional law as adjunct law professors at 2 of Indiana's law schools. Before long, the Indiana Board of Law Examiners informed bar applicants that they could be tested on Indiana constitutional law, and bar review courses began including it in their subject matter. Incidentally, only 11 states currently list state constitutional law as a tested subject on their bar exams. Indiana's state constitution was finally getting the renewed respect and attention it deserved. It was not lost on lawyers. We saw an increase in case filings urging applications of the Indiana Constitution, producing an uptick in oral arguments on the subject and resulting in a growing number of opinions addressing these issues. In ensuing years, the Indiana Supreme Court issued several opinions in which we separately analyzed and interpreted our state constitution differently from federal jurisprudence. We did not choose a lockstep approach. Rather, starting about 30 years ago and continuing to the present, the Indiana Supreme Court has synthesized, articulated, and employed a state-specific originalist methodology for construing our Constitution. We have said in several cases that interpreting our Constitution is, and I quote, a search for the common understanding of both those who framed it and those who ratified it. Furthermore, the intent of the framers of the Constitution is paramount in determining the meaning of a provision. In order to give life to their intended meaning, we examine the language of the text in the context of history surrounding the drafting and ratification, the purpose and structure of our Constitution, and the case law interpreting the specific provisions. In construing the Constitution, we look to the history of the times and examine the state of things existing when the Constitution or any part of it was framed and adopted to ascertain the old law, the mischief, and the remedy. The language of each provision of the Constitution must be treated with particular deference as though every word had been hammered into place. That collection of principles was basically drawn from case law in Indiana from the time shortly after the adoption of our 1851 Constitution. To illustrate how Indiana has applied its state constitution, here's a brief sampling of some of our constitutional law opinions during the past 30 years. The Federal First Amendment addresses freedom of speech with these words: Congress shall make no law abridging the freedom of speech or the press. But the Indiana framers chose more expansive language. They wrote, and this is not unlike Alabama's Constitution either, no law shall be passed restraining the free exchange of thought and opinion or restricting the right to speak, write, or print freely on any subject whatever. But for the abuse of that right, every person shall be responsible. In 1991, our Indiana Court of Appeals faced a claim that Indiana's provision protecting free speech on any subject whatever even protected obscenity. That had been the holding of the Oregon Supreme Court based on an identical provision in the Oregon state constitution. The Indiana court rejected that claim, however, noting that statutes criminalized obscenity both immediately before and immediately after the adoption of the Indiana Constitution, and it concluded that the framers and ratifiers intended an implicit obscenity exception to Indiana's on any subject whatever text. 2 years later, in what one law professor deemed a landmark opinion, The Indiana Supreme Court addressed a free speech claim exclusively under our state constitution instead of the federal First Amendment. There, the court reversed a conviction for public indecency resulting from a New York Eve reveler's boisterous complaint against a police officer who had arrested the defendant's friend. We held that the state may not punish expression if doing so imposes a, quote, material burden upon a core constitutional value, unquote. Turning to Indiana's religious liberty clauses, our Supreme Court opinions include one in which we expressly declared that our Constitution's framers and ratifiers, and I quote, did not intend to afford only narrow protection for a person's internal thoughts and private practices of religion and conscience, but rather protected the full exercise of opinion, of religious opinion in accordance with personal conscience. In another case, we held our Constitution's counterpart to the Federal Establishment Clause was not violated by a program whereby public schools provided teachers and internet access to parochial schools. And in 2013, we unanimously held that Indiana's school voucher program did not violate the religious liberty clauses of the Indiana Constitution. So we have been vigorous and active in looking at our state constitution, independent of the federal Constitution. The Indiana Constitution's Confrontation Clause declares that in all criminal prosecutions, an accused shall have the right to meet the witnesses face to face. This homespun face-to-face addition to the federal language has resulted in a series of cases in which the Indiana Supreme Court has focused on the state provision instead of the federal one. And Indiana's prohibition against unreasonable search and seizure is almost identical, word for word, to the federal amendment. And so is Article 1, Section 13 of the Alabama Constitution. But Indiana's decisions have adopted an analysis different from federal Constitution. We've expressly declared that the federal Fourth Amendment's reasonable expectation of privacy test under Katz v. United States does not govern the state's constitutional claim. Instead, we applied a different analysis for the state provision, explaining that the reasonableness of official behavior must always be the focus of state constitutional analysis. In one case, we held, quote, the use of a valid warrant does not necessarily result in a search which is reasonable in the Indiana constitutional sense, and the failure to use a warrant does not necessarily result in a search which is reasonable. Indiana has formulated a three-pronged test for reasonableness under our state constitution. One, the degree of concern, suspicion, or knowledge that a violation has occurred. Two, the degree of intrusion the method of the search or seizure imposes upon the citizen's ordinary activities. And three, the extent of law enforcement's needs. Another search and seizure case involved a challenge to Indiana's seatbelt laws in the early 1990s. In upholding that statute, we did it with a qualification, providing that the arresting officer had reasonable suspicion of violation. We explained, quote, rather than employ federal concepts like warrant requirement and probable cause, we require instead that the state bear the burden of showing that in the totality of circumstances, the intrusion was reasonable. Some of our most interesting state constitutional law cases have arisen under Indiana's Equal Privileges and Immunities Clause, granting to any citizen or class of citizens privileges or immunities, prohibiting laws granting to any citizen or class of citizens privileges or immunities which upon the same terms shall not belong equally to all other citizens. In 1994, we trudged through some 140 years of often conflicting opinions to synthesize and formulate a comprehensive approach. Now we've held, and our jurisprudence is pretty firm, to determine a state's validity under that clause, we employ a two-part standard. First, the disparate treatment accorded by the legislation must be reasonably related to inherent characteristics which distinguish the unequally treated classes. And secondly, the preferential treatment must be uniformly applicable and equally available to all persons similarly situated. In performing this analysis for Indiana's Equal Privileges and Immunities Clause, we expressly declared that we do not follow the federal equal protection analytical methodology. And in the past 10 years, we've seen an increasing litigation under this clause. To give you some idea of our decisions there, we've applied the clause to strike a local ordinance that unequally imposed no smoking regulations on similar types of businesses. We struck a special statute of repose that applied only to certain asbestos injury claims. And we upheld the Indiana voter ID law as not violating that provision. Similar to Article 1, Section 13 of the Alabama Constitution, Indiana has an open court and right to remedy clause. This has no counterpart in the federal Constitution. The clause has been frequently at issue. In one case, we applied the clause to modify a strict occurrence-based medical malpractice statute of limitations, and in another, we allowed an unauthorized immigrant to pursue tort claims for decreased earning capacity damages. In a claim challenging Indiana Products Liability's 10-year statute of repose, we upheld the provision, but in doing so, held that substantive rights under the right to remedy clause do not follow federal due process analyses, but the procedural rights do. Since 1990, various other clauses of Indiana's Constitution have been applied in ways differing from federal jurisprudence. Among them, provisions addressing double jeopardy, proportionality of sentences, right to jury trial, cruel and unusual punishment. Bear in mind that while I've been focusing on provisions protecting individual liberties, each state's constitutions is actually primarily concerned with governmental structure and operations. These provisions likely have no federal counterpart and do require individualized state-based analyses. Indiana cases of this type have included challenges to Indiana's educational system and its funding, our state property tax assessment system, and various claims of procedural improprieties by our General Assembly. And you get the idea. Together with the cases I've mentioned, many Indiana court provisions during the past 30 years have clearly signaled to litigators and to judges that the Indiana Supreme Court has been serious about construing and applying the Indiana Constitution. And in fact, in one 1993 case, the appellant raised only federal constitutional issue and the court ordered supplemental briefs, noting that Indiana Constitution assures the accused of the right to be heard by himself and counsel, and that it placed a unique value upon the desire of an individual accused of crime to speak out personally. I hope this brief sampling illustrates the experience of one of your sister states, Indiana, and the rejuvenating of our state constitutional jurisprudence. In conclusion, state constitutions are an integral part of the fabric of American federalism. They have not been rendered irrelevant by the federal Constitution. In each of our states, our forefathers intended the carefully crafted words of the state constitution not only to guide the operation of state government they created, but more importantly to protect its citizens by limiting the power of that government. For most purposes, our state constitutions are as binding today as they were when they were written. Thank you.
Thank you, Justice Dickson. We have a few minutes until our next panel, which begins at 1:10, so you have about roughly 5 minutes to go to the restroom and prepare for that. Yes.
Are you taking questions?
We don't have time for the next panel, unfortunately, but the justice may be here to answer some questions and ask anything else. We'll see you at the next panel. Just a few minutes.
Yeah, you trained your bar. Well done. Yes.
It takes a while.
We had, governors continue budgets on when the legislature we had governors to change the law when or allow the law to change. State statute says only the legislature can do it. So I've had certain cases like that where the governors, I find it quite interesting. I wonder if the
So we actually have the John Adams version. It was on his. That's too.
that to me has been the most useful.
And that's been uniform. Because we did much